Mr. Martinez.
Mr. Chief Justice, and may it please the Court, petitioners have made very clear this morning that they're trying to ask you to overturn not just Colorado II, but really 50 years of campaign finance law. This is a highly politicized case, and I think the first place to start is with jurisdiction. No petitioner here is properly before the Court. When Mr. Francisco was asked about that question, he went right to Vice President Vance. So I'd like to talk about why Vice President Vance's claim is moot, and there are two reasons. First, Vice President Vance has repeatedly denied having any concrete plan to run for office in 2028. Petitioners say that uncertainty is enough to prevent mootness. That's wrong as a matter of law. The heightened test for mootness that they invoke only applies when the mootness doctrine is being invoked to potentially manipulate the judicial system. Usually it's a defendant, sometimes it's a respondent, and usually that person is voluntarily stopping the conduct that triggers the injury. You made all this clear in your 2001 City News case, which is really on all fours here. There's no manipulation of the facts in this case, so Vice President Vance's claim is moot unless he has a concrete plan to run. Does he? Well, his public statements repeatedly, over and over and over the course of the past year, including in new comments that were reported this morning by NBC News, show that he has no concrete plan. If any other plaintiff in this court told you that his injury is speculative, that it's uncertain, that it's premature, that it might happen and it might not happen, they wouldn't have a prayer under Article 3. The same rules apply to the Vice President. There's no politician exception to Article 3. Even if you disagreed with me about Vice President Vance's standing because of his concrete plan to run, there's also the absence of any real-world credible enforcement threat. The executive order bars the FEC from enforcing the law. No one thinks President Trump is going to enforce this law and target his own vice president. And the Solicitor General's suggestion that private parties are the ones to worry about runs headlong into whole women's health, where you said that the threat of private party enforcement cannot create Article 3 jurisdiction. I'd love to talk about the merits as well and the radical nature of the arguments we heard this morning, but I also welcome the Court's questions.